All right, the chair's bill, good afternoon, colleagues here on House Bill. We're here for a Business Rights Subcommittee. We're going to start by briefly talking about House Bill 581. We basically had two bills, House Bill 581, and we had the Vice Chairman's bill. What number was that?
1326.
1326. I know it's here somewhere. And we reviewed that. I don't know if you guys had a chance to actually read the legislation. I read all the legislation. I met with council, talked to the chair. The chair said he agreed with what we were talking about, Laura. Is that what he told you as well, right?
Mm-hmm.
Yeah, and so we have a basically we have the product that we're going to be working from. And it obviously is going to be the chairman's bill, but we tried to salvage as much as we thought we could without losing something on the floor into both bills. If Laura, you want to just lay out kind of where we are now?
Sure. I'm going to share a screen. I apologize I wasn't able to finish the amendments in enough time to send it out to you all in advance, but this has been...
Mr. Chair, can I, before we get started on this, can I make just a quick statement?
Sure.
Sure, thank you. So the last work group meeting that we had, at the very end of that work group meeting, Chair Kelly brought up an interesting and I think a poignant point, which is this bill that we're trying to pass here is through the lens of COVID, right? So the lens of what's happened. And it's probably not that hard to think about, okay, what would legislation look like if a COVID situation happened? But what she was actually saying is, imagine there being some other event, nothing like what we're talking about here, and understanding that that event probably will trigger this legislation to move forward. So anything that we're doing with this piece of legislation, her example was a nuclear attack, okay? Maybe a dirty bomb in Baltimore. And so if we're going to pass legislation, how can we draft it in such a broad way that allows for any potential catastrophic health emergency? And Chair, let me finish. And I insist on whatever it is we move out of this committee we're not talking about COVID. We're talking about unless you're going to change the bill and say, okay, just for another COVID event. But this bill can't move unless it's broad enough and flexible enough. The governor had 30 revisions to his executive order, 30 revisions over a period of a year, which demonstrated a tremendous amount of flexibility to deal with the situation at hand. And now we're trying to take unyielding statute and legislation to create a mechanism for any future event. I brought that up at the beginning. I didn't talk last week, but that's where I am. And I think we need to make sure whatever we're moving maintain some principles that Chair Kelly brought up at the last work group meeting. So
if you would just listen to Laura, I think a lot of your worries may be dealt with. Because when I say we went in with a scalpel, it was a very thick, heavy scalpel. And we cleaned this up for just those reasons. I understand and believe me, that's the other thing I want my colleagues to understand on this side. And I think the vice chair was there as well. There's a lot, Chair Kelly has a lot of reservations about this.
Yeah.
So what I'm doing, I'm trying to narrowly tailor it for a health emergency. And two, we're trying to make sure it's something, again, that we can not only get out of the House, but get through the Senate, because I don't want to throw a baby with a lot of bathwater. So if we let Laura just tell us what the points that we're going to deal with, again, this is not exhaustive. If there are other things that the subcommittee feels we need to pull back in, but I've narrowed it down, and talking to the chair, he agrees with what we pared this down to. Go ahead, Laura.
Okay, let me share screen. Oh, good, Delegate Queen's here now. Okay. So just kind of stepping back a little bit, the revisions that Delegate Wilson discussed with me yesterday take out the hazard pay provision of the bill, the part of the bill that requires an employer to provide financial assistance for health costs. It takes out bereavement leave. It limits the health leave to 40 hours. And he wanted to have a conversation with the subcommittee about whether there should be a distinction for employer size with that leave being paid or unpaid. Currently, it's paid for all employer sizes. So I'm going to walk through the reprint, but I'm just kind of trying to give you the highlights. The scope of the emergency is limited to public health emergency that's declared by the governor through an executive order, a proclamation, or a declaration. As to which essential workers would be eligible, that would be based on whatever a federal agency or a state agency determines is critical in responding to the emergency. Let's see. This part of the bill changes. Initially, the Maryland Emergency Management Agency and local emergency management agencies were involved in kind of publicly announcing to employers that the requirements of the bill were in effect, specifically hazard pay, the leave requirements, and the financial assistance with healthcare costs. So this section that you see on the screen instead changes that to the Secretary of Health. So the Secretary of Health would be making that announcement. The thinking being that if this is now limited in scope to a public health emergency, it may be more appropriate for the Secretary of Health rather than MEMA to be sort of announcing to let employers know there's been an executive order or other action that kind of triggers the requirements in the law. And then in turn, the Secretary of Health would make an announcement publicly in writing when the emergency has ended that employers would no longer need to comply.
Laura?
Yeah.
During the work group, we had consensus on using the following phrase: catastrophic health emergency. Is there a way for us to adopt that language in whatever it is that you're working on?
Yes, I think that is what I did. Let me go back up. Okay, so I had put emergency means a public health incident, occurrence, or outbreak that is the subject of an executive order, executive declaration, or executive proclamation. So you would.
We spent a decent amount of time on that during one of those work groups, and
yeah,
why catastrophic health emergency, that verbiage was important is because a public health incident, I think that broadens it. What we're trying to do is reserve this kind of legislation for the very most difficult and severe impacts. And we're not talking about a hurricane that hits Somerset County. We're talking about something that affects Garrett County the same way it affects, Worcester County as it affects Montgomery and Baltimore City. So that, I thought we had agreement in the work group at that specific phrase in catastrophic health emergency.
Remember this, whatever you guys agreed on the work group sounds great, but that's not why we're here. And one, that's semantics. If you want it in, that's fine. No matter what you say, it's going to be something that we're not going to identify, or legislatively is not going to. It's the Secretary of Health is going to be one to determine it. They can call it an emergency. If you'd like them to call it a catastrophic health event, potato.
Chair, is this another walkthrough? Would you just like for me to sit and listen?
No, sir. No, sir. I mean, we're going to walk through it, so I don't mind. I'm just saying I don't want to get caught up so much on the work group, fought and decided, because we still have decisions to make too. And a lot of things. I just want to make sure, I don't mind you voicing your opinion at all.
Well, that's what I just did. All right.
I know that's what I just, right. I disagree mildly, but I got you. And again, if that's the language that we want to use, that's fine.
Okay. Noted. I have added that to the draft. Let me scroll back. What's being struck here on screen is the section of the bill that laid out the different industries that essential workers would need to work in. So instead, as we discussed, sort of under what Delegate Wilson was proposing, it would just be as determined by a federal or state agency, identified by state or federal agency as critical in responding to the emergency. Looks like the chairman is joining us.
Great, now we're in trouble.
Okay. One thing I will point out is the work group also discussed making the governor or the state sort of generally make the announcement about an emergency being in effect. I'm not sure in practice how that would work because the governor is making the executive order, declaration, or proclamation. It seemed to me that perhaps it should be an agency that is making this announcement so employers know officially that the requirements of the law are in effect. But that's something I just want to mention in case there's sort of a different line of thinking within the members of the subcommittee.
So the governor merely announcing a state of a catastrophic public health emergency would not be enough, you're saying?
I guess I'm not sure.
Or if he doesn't, are you saying because if he doesn't use the words catastrophic? Because that's what I was worried about too. If he doesn't use the correct verbiage, does that mean we can't use any of this bill? Is that what you're going at?
Yeah, it does seem to me that it would be helpful for employers if there's an agency that's making explicit what the governor just did or said means that now you have to comply with the requirements of this law. But that was just what I was thinking. I certainly am not holding to that. That was just my line of thinking. I don't know if it's necessary or not.
I mean, that might be a good point, colleagues. And again, we'll circle back around these questions because, if the governor uses uses some liberal language that doesn't have it specific, do we need to interpret? Would that be the Secretary of Health again? So, okay, we've noted that.
Okay. This section of the bill lays out some general requirements for employers. The only change made to this section is, this was discussed in the work group, taking out references to PPE because we don't know in the next emergency if it's going to be something else. So instead it just says safety equipment. The next section is the provision that lays out the right to refuse. There was some amendments that we received from the Maryland Hospital Association and other healthcare organizations, sort of identifying the unique circumstances that those workers are in a public health emergency. And so the changes that you'll see to this section establish an exemption from the right to refuse. That's after line 28, you see the subsection does not apply to an essential worker who is, and this is language from the Hospital Association and the other groups. So those workers would still be protected from adverse action if they let an employer or the Commissioner of Labor and Industry know that there's an unsafe work, a condition causing an unsafe work environment. They'd be protected from retaliation, but they wouldn't have the same rights as other workers to refuse to go to work. The changes here also up above sort of take out some of the more specific aspects of the definition of unsafe work environment and just say something is an unsafe work environment if it renders a worker unable to perform daily duties and it does not adhere to standards adopted by OSHA or the Maryland Secretary of Labor. Delegate Valderrama had offered amendments to, we discussed this a little in the last meeting, to kind of harmonize a separate bill that she has introduced, House Bill 124. I understand that they have revised those amendments. And so in our discussion today, it may not speak to the most up-to-date set of amendments from Delegate Valderrama, but I did draft this set on that you're seeing on your screen from her first set of amendments. So for what that's worth, there may be some changes that the advocates for those groups are seeking that aren't reflected in what you're seeing here. But in her initial set of amendments, Delegate Valderrama had proposed kind of enhancing the protections for workers that, want to sort of make it known that there's an unsafe working condition. And let's see.
And how did it enhance, how did it enhance them? I mean, you just generalize
So
it.
here it says, it kind of covers if the employee is if the worker is notifying the employer by the media or a social media platform, or seeks assistance or intervention from the employer or governmental entity in making the notification, or if the worker voluntarily uses safety equipment with a higher level of protection than is provided by the employer. So if the employer provides like the medical sort of blue masks, but the worker wants to bring an N95 in, the employer couldn't retaliate. I'm not sure why an employer would retaliate in that case for using a higher level of safety equipment, but that's
And
what
the part about social media, that's, I guess we can circle back around to that because that may be a question. Because I mean, the point, I guess, notifying the essential employee or a government employee, are they saying that they can just get on social media and start complaining about what's going on at their job? And they,
presumably that's protecting workers from sort of more publicly, instead of, it's providing protection for like a public sort of disclosure about what's going on at the workplace.
versus filing a complaint?
Mhm.
Okay. All right, we'll come back around to that too. That's fine.
All right, let me scroll down. The Maryland Hospital Association and other health groups had mentioned that the notification time period for employers was too long. It had been 3 days. So the amendments here would shorten that to 24 hours. That was their recommendation. So a worker, in order to be protected from retaliation, would have to pretty much immediately notify the commissioner or the employer of the unsafe work condition.
And colleagues, the reason I thought that was important, because if this is truly an unsafe work condition, you don't want other people working in that condition for 2 extra days, and especially with, the notice kicks off their right to refuse to some point. The last thing we want is other people working in that condition. If there's a known violation, we want them to know to notify people as soon as they, find out, obviously within 24 hours. All right, go ahead.
The provisions that are struck through here on the screen were in the initial set of Delegate Valderrama's amendments. They take out the specific penalties related to the unsafe work condition. There's a separate set of the part of the bill that talks about more generally violations of the subtitle. This section here is, I understand this may be one of the differences in the newer set of Delegate Valderrama's amendments. Initially, and the work group discussed this as well. Initially, the proposal was to require employers to adhere to sort of standards, an emergency temporary standard adopted by OSHA or a similar standard adopted by MOSH if there's no federal standard, and strike the part of the bill that said an employer had to set up his or her own specific health emergency preparedness plan. I understand that now, I think the new set of amendments has some sort of template plan that the Commissioner of Labor and Industry would develop, and then employers would have to kind of adopt that and modify it. So that may be a discussion point for the subcommittee as to whether you want to sort of add that requirement or keep that requirement in the bill, or just say that employers would just be complying with sort of existing standards.
Right. Okay.
Let's see. This section of the bill is about minimization of risk of transmission. There had been some discussion in the work group specifically about the evacuation part. So that is struck from this version so that it says that during an emergency, the essential employer is required to take proactive steps to minimize risk of transmission, including informing workers that they may have been exposed. So it takes out the evacuation of the work site. We received some specific sort of feedback that may be more difficult for some workplaces to evacuate until something has been sanitized, particularly in a healthcare setting where presumably the whole workspace is probably needing constant sanitization. This section of the bill required an employer to pay for testing. And so the language here instead kind of adds a caveat that an employer is not subject to the requirement to pay for testing if the worker has obtained the testing free of charge. As it currently exists, a lot of Marylanders have access to free testing. So we don't know what that might look like in the next public health emergency, but that came up in the work group. I think the retailers brought that up, that may not be necessary or even fair to require employers to pay for testing if the workers have access to free testing. This is a section of the bill that covers bereavement leave and health leave. So this version of the bill removes bereavement leave and brings in some of the provisions of House Bill 1326, the Vice Chair's bill, as it relates to the health leave component. So the bill, House Bill 581 as introduced, was specific to a worker's health needs, whereas the Vice Chair's bill brought in sort of the health needs of a family member, which is more in line with the Maryland Healthy Working Families Act, our sick leave law. So under this version, the health leave would be for the worker or the worker's family member, and the family member has the same definition as under the sick leave law. It would be at least 40 hours, so 5 days instead of 14 days. The employer, this is the subsection C here is the allowable uses for taking the leave. Those are brought in from House Bill 1326. Essentially quarantining, caring for a family member. It also has in like the closure, if the business was closed, due to a shelter in place or stay-at-home order to care for a child or other family member. If the person has a pre-existing health condition that makes them especially susceptible. And then this section here, subsection D, brings in some of the construction provisions from the Healthy Working Families Act to help make it clear how this new category of leave sort of relates to other types of leave. So this says that an employer wouldn't need to compensate a worker for any unused leave. It doesn't preempt essentially any other laws that may provide for more generous benefits. You'll remember that earlier in the pandemic, there was a federal bill that provided paid leave, emergency paid sick leave to a lot of workers. And so this would sort of allow for something like that. Also says that this doesn't preempt, limit, or otherwise affect workers' compensation benefits or prohibit an employer from adopting or enforcing a policy that prohibits essentially abuse of this leave. And there's one more. Or prohibit an employer from providing additional leave. Then this section here, subsection E, talks about documentation. I think that's something that the subcommittee should talk more about. Under the sick leave law, there's a verification requirement. We discussed this at the last meeting in depth in light of House Bill 350, which is Delegate Adams' bill about verification. But if a worker misses more than 2 consecutive scheduled shifts, the employer may request verification. Or if the parties agree upfront at the time of hiring that the that the employer is going to require verification towards the end of a seasonal employment. In that case, the employer can require verification. This language here says that an employer may require a worker to provide documentation, which is different than sort of verification after the fact. This language also says that if a worker fails or refuses to provide documentation, the employer may deny a subsequent request to take health leave during the same emergency. It was kind of hard for me to conceptualize different options here. I know Delegate Wilson wanted to make sure that employers had the ability to request, information from the worker, such as I received a positive PCR test, or we don't know what the next health emergency is going to look like, but I'm not sure exactly how you want to go about this, Delegate Wilson, but this is different from how the sick leave verification requirement works. It seemed like in our conversation, you were requesting documentation more upfront. Like before you take the time off, you would say, I need to quarantine for X period, or I need to be home with my child for X period. And so it's a little different than the traditional cold or stomach bug where people may not know how much time they need off. So that was kind of my thinking based on our conversation.
And that was where I was getting to the second part of the 5 days or whatever number of days, because they can also use sick leave, is find a way, because this is, obviously this pandemic is not the end all, but that's what we're working with. You also, I don't want them to be out 3 days with COVID and then let people know, oh, by the way, I had COVID for, if I want them in this health emergency to notify their employer of their situation, so the employer may need to take additional actions, which is why I thought, verification of the would be more important, documentation would be more important than just verifying after the fact. And again, we as a subcommittee can come back on that if there's a better way of doing it, but that was my concern. And again, if the language is impossible, maybe we would have to revert to the verification process already used. Concerned of people sitting around, taking sick leave, but not explaining it's because they have COVID or they came in contact with their father who has COVID, and now they gotta, sit with them. But all right, so that's fine. We'll come back around to that too.
Okay. Added a provision that the commissioner would be required to adopt regulations regarding forms of documentation that an employer could request. That seemed like something that could sort of generically make clear what's appropriate to ask for and the circumstances under which the employer can ask for that. The section of the bill of the reprint takes out the hazard pay and healthcare costs provision of the bill. This is the misclassification part of the bill, and so the only change there would be to remove reference to hazard pay. This is the enforcement and remedies part of the bill, and there are no changes to that part of the one change that Delegate Wilson discussed, this came up in the work group with the vice chair, the reference to compensatory damages and sort of the, point that the commissioner doesn't typically sort of assess or impose damages. So I think the intent here was to potentially take out compensatory damages and just say any other relief necessary to make the individual whole.
Yeah, that's the compensatory damages seems like a little pit to jump in for no reason. Okay.
The only other thing that I think I said when I mentioned compensatory is whether or not it should say economic damages, which are, specifically defined as, whether it's lost pay. Compensatory means, we found you did something wrong and we think you should get some huge amount of money. Economic damages, I think, relates to, your healthcare costs or, the time you lost from work, unless that's someplace else there and I missed it. Back pay is there.
Okay.
Or maybe, economic
Doesn't
costs,
hurt.
maybe not damages.
Yeah, it doesn't hurt. Cost and damages, I think, synonymous in this setting, but it doesn't really.
That's fine. Yeah, but economic, not compensatory.
Yeah, that's fine.
Okay. All that's left in the reprint is the part of the initial set of amendments from Delegate Valderrama that requires basically the state to follow some sort of COVID-specific emergency temporary standard. I think that this provision of the bill is similar in the newer set of Delegate Valderrama's amendments, but I haven't been able to closely match them up. And let's see. This requires, section 4 here requires, let's see, reporting from MOSH about sort of the complaints that they've received, site inspection, citations that would need to be submitted to the General Assembly before January 1st of next year. And the Commissioner would be required to adopt regulations ASAP. Yeah. That's it.
Good job, Laura. All right, Chris, and I know, that you've heard everything, and this is for the entire committee, of course, but since, I cut Chris off mid harp before to give him an opportunity. And again, there's no decisions that have to be made today, guys. We're not in a rush. But as I said, we're going to have a work product. There's some things we're going to do. Is there any parts of the bill besides what you've heard that we think we've left out? And Chris, I know you and the chair on the work group is there anything that you think that we forgot to cover?
Mr. Chairman, I'll just finish by saying that what I said at the outset is I think that there's some global concerns I have with any piece of legislation we move forward. And then now that I've stopped and listened to the presentation, let me just say up front, I've not seen the reprint, right? So we're going through this, and that's great. We're doing a flyby over what the changes are, but to have a substantial conversation to the extent that you're asking for and need us to engage, I need to sit down with the reprint and just look at it myself. And the work group, that was 6 hours of engagement on this issue, and I'm trying to determine whether some or most, or I can see some of it's in the amendments, but it's very hard to tell. But that was a fairly lengthy process. I'm not going to say anything other than the fact I think I'd like to see the reprint.
Well, that's why we were just covering it briefly. Once our eyes on the reprint, that's why we're not making any decisions today. I just think, well, before we get the reprint out, and I know if this is too big of a flyover, that's fine. I just don't know if there's something that we all thought should be popped back in. I see some hands up.
Mr. Chair, the only thing, and I think I'm getting my bills confused, to be honest, because some of them are all similar. But is there a provision here for sort of a special open session for the health exchange, and I missed it, or am I thinking different?
No, I did not cover that. So thank you for bringing that up. That was in the bill as introduced. Some of the health insurance carriers recommended removing it. I understand the advocates want to resist that, but I believe that was an amendment that the chair was going to offer for discussion purposes as to whether, so my understanding is currently there is a special enrollment period that's open through May 15th related to COVID, but that's not to say that in a future emergency, there would always be a special enrollment period open.
Okay, well, I would just leave that for discussion. I don't think
And I want to make sure
for COVID, but yeah.
I just want to make sure everybody has a chance to see the reprint before we jump in. But yeah, especially anything that's missing. I don't know whose hand was up first. Sorry, guys. I'm gonna go middle of the out. Delegate Queen.
Thank you, Mr. Chair. I may have missed this, and it's just one area. When we talk about emergency employees, and I think we say we're going to use whatever the governor says or whatever, some point to some other place to get that information. One of the amendments asked about daycare providers, and I don't know if they were ever listed in the governor's list of providers, but we found that essential workers couldn't go back to work unless they had daycare. So I don't know how you handle that, but I don't want us to forget that that amendment or somehow needs to be addressed.
Right. And I know we also have to, Laura, I think we talked about the, I don't know if we covered, is this going to be applied to, I think this applies to all employees, not just the 15, the side business we were going to apply this to. And also, are we talking, because I know there was an issue about contractors versus just people, employees, there's, what standard are we going to hold people 1099s and contractors and subcontractors to versus employees? And I wanted to talk about that once we've all read the bill as well. I said, because I have issues with, individuals being held to an employee standard when they're actually a contractor when it comes to stuff. So I know we need to discuss that as well, along with, again, the childcare. That's going to be difficult because how to quantify, are we going to make a specific carve out for childcare and what other carve outs we're going to have to make? Delegate Turner?
Yes. I want to know the rationale about hazard pay. Why did the Maryland Hospital, why do they want to take this out? You went so fast. I know you said it. But can you just back up a little bit and tell me the reason why y'all are stripping it from this bill?
It's none of this is me doing anything. I'm just drafting what I'm asked to draft, but I think Delegate Wilson had some concerns about the hazard pay part of the bill.
Number one, the fiscal note is stupendous. The hazardous duty can't just be for private industry, it would also be for government employees. And I believe that would be a true poison pill in this bill as far as getting anything out. Grave concerns with the fiscal impact and on any and every business operating about a $3 hazardous duty, pay. And again, these are all things that are open for discussion, but the goal for me was to try and get something out and make sure that we can forward looking for this pandemic and God forbid the next one. But I know that when the talk of hazardous duty pay is pretty much turns everybody against it. It's a huge financial burden, and especially for businesses, for government operators, for contractors. They were locked into a certain pay because that's what they agreed that's what the living wage was, or that project labor agreement says. All these individuals are locked into this pay scale, and to bump everybody up $3 an hour with no rationale, with additional income coming in is very, very detrimental to almost every business.
Okay, and one more thing. I was trying to follow you on everything, and she printed out the amendments and everything with me. And I see that you had several people in the work group because you had the unions in the work group. Mm-hmm. And the part that I wanted you to tell me again is about the people, the employees that refuse to come back to work. Mm-hmm. So you're saying that they will not, unsafe place to come back to. They won't lose their jobs. Let me just try to put it so I can understand it. In this bill, if they refuse to come back to work, are they going to be penalized for that and lose their jobs? Or is it going to be a part in this, in there, if they can prove that it is hazardous to their health, they won't lose their job and they'll get all the equipment that they need to be safe on the job? I'm trying to look out for the working people, the essential workers. Okay, I might have missed it. Okay.
Yeah, no, so there's a part of the bill, and I can pull it up on the screen again if you'd like me to, but
just where it is under what, 16 something, whatever.
Remember, you might not have her reprint.
Yeah,
I don't have a reprint. Okay.
Right.
Yeah, I can share screen again. So hold on one sec. let me just explain it to you and then I'll find it in the
Yeah,
bill.
just-
But
just- yeah,
there's a section of the bill that protects an essential worker from an adverse action or retaliation for reporting an unsafe work condition.
okay,
What the amendments that we were discussing today, that Delegate Wilson is sort of offering for discussion purposes, change the time frame within which a worker has to report the unsafe work condition to be protected under the law from retaliation. So the bill initially gave a worker 3 days
yes,
report to the Commissioner of Labor and Industry or
Uh-huh.
the employer. The Hospital Association and some other health groups had suggested making it 24 hours.
within
So
4
that-
hours.
So the amendments that we were discussing this afternoon shorten that to 24 hours. So in order to be protected from retaliation, a worker has to report the unsafe work condition within 24 hours, as proposed.
Now, none of this has been accepted yet, right?
Nope.
Okay, okay, I just want to be sure. Okay, thank you, Mr. Chair.
Everything is open for discussion. Yeah, I was trying to think, of course, getting text as we talk about federal hazardous duty pay that's out there and
Yeah, Delegate Walls, Mr. Chairman, can I jump in on that point?
sure, Mr. Chairman.
Yeah, I know that has been a concern for a number of folks. To be honest, that was one I was going to take to the presiding officer and ask about, what is it, the American Rescue Plan. I believe that there's allowances or for that. So that, I guess what I'm trying to say is that's something that a decision that I think will be made above my pay grade anyway.
Okay.
And if they, if they want to go that direction, budgetary decisions are generally out of the purview of this committee, in terms of that sort of thing. So I was going to speak with the speaker, about any plans for that well, I guess I can't say it any clearer than that. So that's what my thinking was, as opposed to trying to do it here to do that there.
And I appreciate that, Mr. Chair. That's and also, by the way, whoever's listening and text me, I don't know who you guys are if you don't text me your name at least.
Well, no, they're not supposed, Delegate, Mr. Chairman, they're not supposed to be texting you while you're running the
that
meeting.
so many times at this point, I'm like, I just don't even know who you guys are. But
just tell them to stop
but what I
and
want to
let
say
you run
is,
the meeting. Well, matter of fact, I'll do it. Stop.
well, what I wanted to say is, this is not set in stone. And again, I apologize for snapping on Chris because I realize now it probably came off like kind of dickish, and I apologize. But
Chairman, you're not snapping off at me. This is a contentious bill.
yeah.
Matt Middleton used to say something. This is a very important bill, but it's a very controversial bill.
There you go.
This applies in both those instances.
And it's hard but we're trying to, I just want something of value to come out, and trying to avoid all the missteps. So we're going to get this bill out to you guys so you can read the reprint. We will be meeting quite a few times this week and next week. We don't have any more bill hearings, to my knowledge, and might even meet again tomorrow on this. I know we have other bills to go through. So when you guys get your bills, I'm not trying to talk y'all like children. As you're reading through, man, take notes. If you think there's something missing, especially if you think there's something about employee protections, if we don't have the scope right for the employees that we're trying to protect versus the contractors, if you think the enforcement is too weak or too strong, I don't want to create another boutique law firm that just goes after stuff like this. But I do want individuals to have protections. So when you guys go in, that's the purpose of having all these eyes on the bill. And then we'll come back again probably tomorrow, or if not Thursday or Friday, and we'll discuss again. Laura, any want to go over some of the other bills? Oh, and also when it comes to dealing with anything, and this is just my idea, I know we have other bills having to deal with the Maryland Healthy Family Workers Act. My goal is to deal with this pandemic as we have it. There are other bills that alter the Maryland Healthy Workers Act. It's my preference, if we could, to, I'm not saying say that for another year, but right now we need to work with what's in front of us. This is a very heavy lift. I know we have 2 other bills that deal specifically with altering the Maryland Healthy Family Workers Act that we're going to discuss, but some of these things may have to be laid over for another year until we can get through this issue. Go ahead, Laura.
I don't have anything to add. You know, we did the walkthrough of the bills on Monday. Are you wanting them to vote on the sick leave bills?
No, I'm just giving
Not
my
yet.
2 cents. Not yet. Again, we're not in a big rush. We have an electricity bill coming through. Apparently the Senate did pass it, so it's one we've worked on for years, guys. It shouldn't be that big of a deal. Hopefully, we'll be in the same posture. As you may have heard earlier, there's an airport bill that it's in our. I think that's just going to go to full committee. Dealt with it in a work group session. So
You're talking about the secure wage bill?
oh God, no! I was talking about the airport bill with the
Okay. That one's coming back too. It was in subcommittee and the Senate passed it in an amended form.
Which one?
Which
For
one?
us,
Secure
it's
wage.
House Bill 685, I believe. Delegate Valderrama's bill.
Oh, the Senate passed something?
Senate passed a version of it and it's
Okay.
here. Mhm.
Six
Don't play
eighty- what-
poker, Delegate
six-
Wilson.
I'm sorry?
What was the
Don't
number
play
again?
poker, Delegate Wilson.
I believe it's House Bill 685. The subcommittee took it up initially and discussed making it a study, and the Senate actually passed a substantive bill.
Well,
So I'm not sure yet if the chair is going to have that go to full committee or back here.
yeah, probably be a, if I had to guess, I'm pretty sure we'll get it. But I just wanted to make sure we're comfortable with this bill, guys. It's a heavy lift. I know we have other, like I said, healthcare bills. I'd like to, if we could, the big one, what we have in front of us, this elephant in the room, and maybe some of the stuff kick back to the next year. But of course, we'll have an opportunity to discuss all of the bills the next time we meet. Are you guys comfortable with meeting tomorrow, or do you need an extra day to review
Tomorrow's fine.
the rewrite? What do you guys think?
Tomorrow's fine.
Yeah. All
It
right.
might take a couple meetings, like you said, so we can start tomorrow.
That's true, and we're not pressed to have this up by crossover.
Right. Tomorrow's fine. As long as we get a reprint, hopefully today we can read it and review it.
Yep,
I
I'll
know-
send it out right after the meeting.
Thank
I
you.
know Laura's been chilling for a few days, so
I was up working on these until after
No.
midnight, and then I worked on them all day, just finished them.
No.
So that's
I know,
why you
that's
all
why-
didn't.
We need a
That's
staff
why-
protection for legislative.
Jerking your chain.
That's why I didn't send it out in advance. I
Right.
appreciate your patience with that, but it's a
No.
lot. The bill's a big bill, so it took a
Yeah.
while to work in all the amendments.
Yeah, she's doing great. So I know you'll get it to us when you have an opportunity. We appreciate your stick to itiveness. I'm sure the whole subcommittee does. Does anybody else have any other questions? Mr. Chair, you have any other questions?
Good for now. Like I said, I'm sure that there are folks listening and they will share feedback as well. But yeah, I pretty much say what I had to say. I'm going to speak with the speaker about that other piece, and we will continue the conversations.
Appreciate it. Madam Vice Chair, anything to say?
No, thank you.
Okay, colleagues, thank you very much. Look forward to meeting with you guys tomorrow, probably same bat time, same bat channel.